how to prepare a settlement demand for a personal injury lawsuit. Now, a settlement demand is simply a piece of paper, and it's got attachments to it, and a person that's injured will send that usually to the insurance company for the person or corporation that caused their injury, and it's telling the insurance company, the insurance adjuster who's looking at it, why they should pay money and how much they should pay. So what actually is a settlement demand? Well, literally, it's like a letter, and like anything else, there's the address at the top, and there's going to be the date. A lot of times people call it settlement demand on the very beginning, and it'll be dear whoever it is. And the first thing you're going to do is probably write a little story, a narrative of what happened. On this date, this occurred, da 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 da, with the details. And then after that, you're going to need to demonstrate liability. Now, liability means that, hey, this person caused my injury, and this is the evidence supporting the fact this person caused my injury. So it can be super simple. If it's a car accident and there's a police report, and the policeman says in the report, this person was cited for causing the accident, then you attach the police report and you say, look, this was already investigated. Officer such and such found that the person you insure caused the accident. They were at fault. They got a ticket. They are liable. So once you prove liability, however you do it, if it's at a commercial place, there might be a incident report, so you're going to want to use the incident report. If there's nothing and you've got witnesses, you can use witness statements. If there's video, you can actually attach video to your demand letter if that's helpful too. But the very first thing you have to prove is that the other person is liable for your injuries, because if you can't prove the other person's liable, it doesn't matter how hurt you are. If the other person doesn't have to pay, you're going to get zero. So prove liability first in your letter, attach whatever documentation you need to prove the liability, and then once you've nailed that part of it, then you get to the damages part. And the liability tells them, hey, you need to pay, and the damages tells them how much to pay. So what do you put in the damages section? Well, if it's a personal injury case, there's going to be an injury. So you're going to have your medical reports and you're going to have your medical bills. Now, lots of people don't like giving their medical reports to other people, strangers. They say it's personal. But in instances of personal injury cases, you're making your injury an issue in the case. If it's going to go to trial, then the jury's going to see the medical bills, or maybe they won't see the bill, but they'll at least hear from the doctors what treatment they gave. So you actually do have to provide bills to the claims adjuster who's going to be analyzing this, and you're providing the records as well. And why are you doing this? Well, because the claims adjuster is sitting behind the desk doing their evaluation. They can't just say, hey, Joe on the phone told me he was injured and it cost $10,000, so I need to write him a check. That doesn't fly. They need documentation. They need to do their analysis. They need to put all that in their file so they can justify making a payment, because claims adjusters get reviews, they get audited, and if they can't support the checks they're creating, then they're not going to do very well in their career. So attach the medical records, attach the medical bills. That'll help the other side figure out how much the medical damages are. Now, sometimes there's more than just medical damages. There's going to be things like lost wages, maybe. You were going to work, you couldn't work for a while because of the injury, so now what are you going to do? Well, you get a letter from your employer, you get pay stubs, whatever it is that shows that you were unable to work due to the injuries, and then whatever your salary is or hourly, you calculate that number and say, hey, look, I lost whatever it is, $5,000 of lost wages, and here's the letter from my employer, here's my pay stubs, whatever it is to prove that. Now, if there's other household things you couldn't do, let's say you were so injured you couldn't do your gardening, so you had to hire a gardener, or you needed to hire somebody to help out in your house, you also include those receipts. If it's a auto accident and your car's been damaged and it needs to be fixed, you've got estimates, you attach all of that. And so what you have is essentially a stack of paperwork that you're giving to the claims adjuster to say, I have this much in medical treatment resulting from the accident, and these are my bills resulting from the accident, and here's my car damage resulting from the accident, and here's these people I had to hire at my house. And you list all of that out. You also tell them that you have pain and suffering, because if you're getting medical treatment, usually you're in pain. And then Also, you're going to include any future medical treatment you might need. So if you've got a doctor and your doctor says you're good, you're back to the way you were before the accident, then you know you've got all of your medical treatment done and you're finished. But if you're not done, you can go to a doctor and say, hey, what other treatment do I have? Or the doctor tells you you need this surgery or you need that treatment. You get that in writing in a medical report, and you include that as well in your demand. And so you've got your liability portion written, you've got your damages portion written, and then at the end, you're actually going to want to make a demand. Say, hey, I demand X amount of money for my damages. How do you come up with that? Well, that's really squishy, and it depends on a lot of factors. That's where it's really helpful to have a skilled lawyer in your jurisdiction to help you out. Lots of times here in Nevada, where I'm at, in a generic type of situation, a lot of times the insurance adjusters will look at these things different than the attorneys do. You'll oftentimes see attorneys look at the medical bills, which is what the insurance companies often use as an anchor, and they might make a demand saying, hey, I want 3 times the medical bills or 4 times the medical bills, and the insurance company is going to come back and say, well, that's ridiculous. We'll give you something less than the medical bills because we don't think it was all that necessary and we think your bills are too high. But your demand letter is just a starting point to begin the negotiation process. So, if you have absolutely no idea where you're at, you might look in your jurisdiction. If you happen to be here in Nevada, you might be making something 3 or 4 times your medical bills. You send that off to the claims adjuster, and at some point they'll contact you. They'll probably make you a lowball offer, and then the game begins, or the dance begins, of negotiating back and forth. You'll tell them why the offer is too low. You'll show them, why, again, their person's liable, the damages you've incurred, and then give them a counteroffer, which is slightly less than your demand. They'll give you a offer that's slightly more than their original offer. Just go back and forth. If you can settle the case, great. And if you can't, then it's time to go litigate. If you've got questions about a demand and you happen to be in Nevada where I practice law, please feel free to give me a call or drop me an email. We can talk about it.